Thanks.
I just briefly wanted to thank a couple of people who I left out in my initial introduction, but I wanted to preserve for the record. First would be Melanie Dunshee from the library. She has been a huge help in helping us take care of all the logistics and make sure we have all of our paperwork filed properly, and we really want to thank Melanie for that. And also, a poor, unsuspecting 2L this morning asked me if he could help with anything, and he has basically been the glue holding this together, and that is Austin Pierce, and I just wanted to thank him for all of his help, for making the mistake of asking if I needed any help, taking the initiative, so carry on.
Okay, we start with Hannah Buxbaum. Is that right?
Okay.
Go ahead.
Okay.
On the top, you give your topic yourself. Good.
Yeah, which is not the topic that's in the program. It's related to the title that's in the program. So let me add my thanks. It's very nice to be back here with Ralf and other old and new friends. So Ralf initially asked me to talk about kind of a broad methodological question, which is unilateralism and multilateralism in U.S. Choice of law, both in the interstate and international context. And I quickly ran into a lot of, there are too many possible dichotomies and axes to talk about: public-private, regulatory, non-regulatory, state, federal, statutory, common law, et cetera. And so I chose as a particular topic within this broader methodological question what is on the slide, which is legislative scope and the presumption against extraterritoriality. So let me start by saying essentially what I want to do is systematize a little bit an issue that Trey brought up in his talk, which is the question of the presumption against extraterritoriality, how it operates both in international conflicts and in interstate conflicts, and whether and how the new restatement should deal with it. So as Section 5 of the current draft reflects, conflicts analysis involves two separate inquiries. We think about the scope of potentially applicable law, which is really a matter of statutory interpretation or judicial construction and interpretation. And second, we think about choice among applicable laws in the event of a conflict, which is a question about the rules of priority that we adopt. In some legal systems or in some particular areas of law, or with respect to some types of law, these two inquiries are kept fairly sharply separated from one another. So, for instance, if we think about regulatory law in general, we ask only about scope. So the question is simply, does the activity in question fall within the scope of forum regulatory law, in which case that law will be applied? There's not, and we can talk about the residual conflict of laws issues, but that's the primary task when it comes to regulatory law. Rules that we categorize as internationally mandatory rules simply dictate their own scope of application, right, to the preclusion of real choice or priority analysis. So there are some areas where these two inquiries are kept quite distinct. One hallmark of American conflicts law, with its eclecticism or functionalism or whatever we want to call it, is that in many areas there is a significant blurring of these two inquiries, which the new draft is trying to, again, sort of keep distinct. So I think that this blurring of the two inquiries is true both in international conflicts and in interstate conflicts. So let me start with the old or existing Restatement of Foreign Relations, so the Restatement Third of Foreign Relations Law. Section 403 of that restatement has a rule that uses international law to set outer boundaries on a state's legislative authority. In other words, it deals with a question of scope, right? It asks, when does a state have the power to apply its law to a particular situation? But the criteria that it uses to analyze scope are actually priority criteria. They are choice criteria, right? So Andy Lowenfeld, the reporter for that restatement, quite consciously borrowed from choice of law analysis the factors that he then used as the criteria to consider a question of legislative scope. So that's a blurring of the two by importing choice of law factors into the determination of legislative scope. On the other side, if you think about our practice as to conflicts of private law in the domestic context, in the interstate context, now here generalization is much harder because we're talking about, many states have different choice of law frameworks. But I think it is fair to say, I'm only going to say it's fair to say it because I've heard Simeon say it before, so it must be true, that the overall framework, if you had to generalize and categorize choice of law analysis in the United States today, you would call it overall a multilateral framework in which priority concerns are dominant. But considerations of scope play a very major role, right? Most prominently, of course, in interest analysis. But even in Section 6.2 of the restatement second, it directs a lot of attention toward whether the issue in question falls within the scope of the relevant laws, because it builds this interest analysis type of consideration into the priority determination. So I think that the state of play today is that in American conflicts law, these issues of scope and of priority are kind of mushed together in a lot of different ways. Both of the current draft restatements, though, revisit this intersection in a way that, in my view, is putting a lot more emphasis on the question of scope. So the draft restatement of foreign relations, fourth, in Section 201, actually removes the consideration of choice of law type factors, that is to say the consideration of foreign as well as American interests, as a required step in the analysis of legislative scope. So now when you're talking about legislative scope in the foreign relations restatement, you're not doing priority type thinking. Early drafts more or less took those factors completely out. The current draft includes provisions saying that courts may take legislative comity into account. They can take reasonableness in various articulations into account when they are deciding whether or not to apply U.S. law, but not in the analysis of does international, how do international law limits sort of define the scope of the law? Not in that at all. And this shift is even clearer in Supreme Court jurisprudence, right? So if you look at the Morrison, Chiobel, RJR, Nabisco line of cases, all of them suggest that you do statutory interpretation to determine the scope of the federal statute. Once you decide the scope, you apply it to all cases that fall within that scope, period. Okay, on the conflict side, Section 501 of the current draft, Comment B, provides this two-step analysis, right? So the first step in resolving a choice of law question is to discern the scope of the relevant state internal laws. If that analysis reveals a conflict between two applicable laws, the second step is to choose among them. Now, if this approach were implemented in the sense of this is the methodological approach we expect courts to take, I think it would elevate scope questions quite considerably over current conflicts law. First of all, as Lee Brillmeyer has pointed out, in some circumstances where the law of the forum directs its own application, right, then you don't get to step two. So we would be deciding a lot of cases sort of on the basis just of step one, the scope question. Second, it seems to me logically, if you follow this approach to its conclusion, courts would need to follow not only statutory directives on scope, which current Section 502 says, but non-statutory indications of internal scope as well. It's not, and I know, Kim, I saw in some of your responses to some of Carlos's comments, discussion on that question. But however, it's not clear to me how fully this two-step approach is in fact implemented in the current draft. I gather that the reporters see the two-step analysis more as a philosophy underpinning the project than as a method that courts are actually going to apply in individual cases. And most of the rules set out in the current draft are really priority rules. They're not scope rules. So I think one question is how consequent the new restatement is going to be in pushing this, the sort of two-step process as a method, actually, of resolving conflicts of law. Okay, so I think in both international and interstate conflicts, we now have increasing emphasis on determinations of scope. This, in turn, highlights the importance of the tools of statutory interpretation that courts use to ascertain scope in situations when legislative intent is not clearly expressed. So I want to talk about, or I want to make the point that there are three different conflicts constellations we have to consider. The first is the application of a U.S. federal statute in an international case. The second is the application of a state statute in an international case. And the third is the application of a state statute in an interstate case. So in case number one, we have the presumption against extraterritoriality, the classic presumption against extraterritoriality, right? So this is reflected in the new restatement of foreign relations. U.S. courts interpret federal statutes to apply only within the territorial jurisdiction of the United States, unless there is a clear indication of congressional intent to the contrary. What about cases 2 and 3? What about situations where we're talking about state statutory law applying either in the international or in the interstate context? Courts, in fact, address extraterritoriality here too, but in a much more disorganized way. So the application of state law in international cases kind of presents the same kind of conflict as the application of federal law in international cases. That is, you've got a conflict between the law of a U.S. sovereign, federal sovereign in one case, state sovereign in another, and the law of a foreign sovereign. But the classic presumption applies only to federal statutes. It does not apply to state statutory law. Some courts cite to it anyway, without explanation. Some courts seem to assume there is some other presumption against applying state statutory law outside the territory of the United States, but they don't source that presumption in any particular rule, doctrine, policy, etc. Some of them don't really use a presumption. They just analyze state statutes if they have federal analogs, like mini RICO statutes, state antitrust statutes, etc. They just determine the scope of those state statutes to be coterminous with the scope of the analogous federal statute. Most importantly, though, in my view, courts do not distinguish between the international and the interstate context. This I find highly problematic because when we move to the interstate context, the kind of conflict presented is really different. It's a conflict between the laws of two U.S. sovereigns. There's no foreign sovereign involved anymore. And for that reason, the rationales on which a presumption against extraterritoriality might rest are very different. And, wow, if you were so right that this is going to take 20 minutes or more. So if I can just get through these two slides, I'll feel like I talked about what I wanted to talk about mostly. if we think about the rationales that are used for a presumption against extraterritoriality, a couple of them are just not relevant at all in the across context, right? So one rationale for the presumption against extraterritoriality in international cases is the foreign relations concerns related to separation of powers, right? So we do not want courts interfering with, matters of foreign relations, et cetera. That rationale is just not applicable at all in the interstate context. Conversely, one rationale that we see emerging in the interstate context is due process, right? So there are cases saying things like, no reasonable citizen of Nevada would have expected that his behavior would be regulated by, et cetera, et cetera. Now, when I say not applicable in international, due process concerns, of course, are voiced, to some extent in international cases, but due process limitations have never operated as meaningful limitations on legislative jurisdiction in the international context. And so they don't show up in the case law as a rationale for the presumption against extraterritoriality. When you look at how the cases justify the presumption against extraterritoriality in international cases, due process is really not among the reasons. Okay, then you have some rationales that look superficially similar in the two contexts, but are actually really different. So, traditional territorialism. In the international context, at a time when customary international law limits prevented the application of law outside the territory of the enacting state, the presumption was really there to guard against the violation of international law. That's an international law problem. A lot of the state cases talk about traditional territorialism as well, but it's not because of international law, right? It's more because they're invoking vested rights type theory, right? They're talking about a time when it was assumed that state law could have no effect beyond the borders of the enacting state, and so a presumption just kind of reflected that view. So both of them are talking about territoriality, but actually anchored in slightly different contexts. This is true also when you talk about the desire to avoid unnecessary clashes with the law of the other sovereign. In the international context, this has a comedy overlay. We're talking about things like, how do you make all the laws of the world work together in harmony, right? To quote Justice Breyer, or paraphrase Justice Breyer, right? On the interstate side, this is not about comedy. It's about constitutional limitations, right? So against the backdrop of the Dormant Commerce Clause, against the backdrop of general principles of federalism, we do not want the laws of one state to interfere with the sovereignty of a sister state. So that both of these are talking about avoiding clashes, right? But the actual legal theoretical framework for avoiding the clashes is different across the two contexts. Okay, so what does all that mean for the restatement? I think that the confusion. So first of all, I think we should address the presumption against extraterritoriality, because if we care a lot about legislative scope, which the draft does, then I think we need to talk more concretely about what the tools of statutory interpretation are that we are expecting state courts to use in determining legislative scope. So I think that's an important topic to cover. I think that this confusion, and the cases are really all over the place here. Like, as I said, they often just cite the federal presumption without recognizing these differences. Some of them don't, well. So let me give one example which comes up frequently in employment litigation and connects to the general debate about Section 502. Contracts in which employees and employers agree that the employment relationship shall be governed by the fair wage statutes of a particular state, right? So they say, okay, the fair wage statutes of Massachusetts will govern our relationship. Then in litigation, the defendant argues, no, our relationship falls outside the geographic scope of that statute because the employment in question or the conduct in question happened in another state. And therefore, that law cannot be given application by means of a choice of law clause. A lot of courts deal with express limitations on scope in that context, right? So they say things like, when a law contains geographical limitations on its own application, courts will not apply it to parties falling outside those limitations, even if they choose it. That's like 502. The court is following a statutory directive on scope, right? But other courts say the same result should flow if the presumption of extraterritoriality is not overcome, because that is like an implicit limitation on the geographic scope of the law. And so it only makes sense to give that implicit limitation bite as well by saying it doesn't apply to the relationship. That is not like 502. That's like following a non-statutory directive on scope. So that, 5 seconds. So that circles me back to the question of, how far toward its logical conclusion the draft is going to push the kind of, scope part of the scope priority two-step analysis. Whether it should, for instance, take account of non-statutory directives or implicit directives, et cetera, on the scope of law as well. And I think the reporter should consider adding material on the existence and contours of a presumption against the extraterritorial application of state law. And this is an area where distinguishing between international conflicts and interstate conflicts, I think, would actually make sense. Thank you.
I love that everyone's afraid of my little iPhone. Horatia, you want to immediately?
I think I'm going to stand up.
Good. I'll follow you with the iPhone regardless.
Okay, thank you very much. I'm standing up because while I could sit down and listen to Hannah because she was so interesting, my own thing might not be so enough to keep me awake because of the jet lag. So standing up will prevent me from falling asleep. So first of all, thank you very, very much for inviting me. This is really very, very instructive. I don't know how helpful I can really be. I've been asked to talk about sort of all federal and supranational systems. So I think I'll just modestly focus on the EU because it's probably sort of the most significant example. But a bit like Richard, I feel a bit floaty about this. Not for the same reasons, but I also represent Scotland, who is part of the perhaps future ex-United Kingdom, and therefore this is a fairly complex situation from the point of view of federalism too. So I'm going to talk about the EU, but of course this is a comparison or some suggestions. The EU at the moment is definitely not in a lesson-giving mode, right? So I'm not sort of going to describe an ideal system. So everybody is probably aware that the EU is currently beset with a certain number of problems, the biggest being coping with the post-Brexit uncertainty. So we don't really know what the consequences of Brexit are going to be whether there's going to be Brexit, actually. What is Parliament going to say? And then if Parliament does Brexit, then what the consequences are on the particular field of private international law and judicial cooperation, so on the European judicial space. And of course, that entails all sorts of technical questions, but also the respective positions of, say, London and the various European capitals in terms of being a forum in commercial litigation, for instance, and also for financial services, etc. So all that is very uncertain and actually makes it quite difficult to talk about private international law in Europe at the moment. And of course, the other enormous question, which concerns private international law in its widest sense, which is actually very much the continental European understanding of private law in certain traditions anyway, which is the external frontiers of the European Union in terms of migration. And this, of course, is linked to very technical questions of personal status or whatever, but much wider political questions. And there again, it's something that the EU is grappling with and makes it difficult to talk about. Apart from those problems, I'd say that globally, and actually this exercise has been very interesting for me, not because I've been trying to look for good things that the EU could sort of advise on, but it's very interesting as an exercise, sort of in a broad brush appraisal of the whole system. There are further weaknesses that I'll add to the current problems. One is, one could use different vocabularies to describe it. So Don Childress was talking about the bigger regulatory conflicts. I would say the global governance implications of private international law, but I mean this is something that EU private international law tends not to consider particularly because it tends to have a fairly narrow technical focus, and I think this is a mistake. You can see all sorts of examples where it would have done well to have a wider horizon. Part of this is part of the Brexit debate. For instance, the impact of private international law and conflict of law rules on the labour market within the EU is clearly, and free movement, etc., is clearly part of the big Brexit question. Another point where I feel that a lot of work could be done, but I don't think this is specific to EU private international law, is to consider a kind of post-national conflicts, and we have very few conceptual tools for dealing with non-state norms and non-state actors, and the way in which such norms might appear in conflicts. And then the last weakness, but I'll go back to that perhaps in a minute, is that the system is very complex. However, having listened to Hannah with all her various hypotheses, I'm not quite sure whether we're really in competition here. But of course, the complexity in the EU, apart from the very, very different cultures that are present here, are the fact that we have two distinct supranational courts, one of whom has a specific scope in private international law because it is the official interpreter of EU law, but the other actor is the European Court of Human Rights, which actually does not edict choice of law rules, but does have due process and other considerations which actually impact very much on the way in which private international law works. And that is complex because, of course, the two courts don't have the same constituencies. Well, they have overlapping constituencies, but they're not exactly the same. However, having said all that, there is an edifice. I hadn't counted the number of EU texts. I haven't done a Simeon exercise. So he said 15, so we have to believe him. But I mean, there are many, many private international law EU special instruments. And actually, there is very little national private international left within the member states. So unless you're talking about sort of personal capacity to enter into a marriage or something, and even then it's probably whittled away slightly, there's practically no field where you haven't got EU private international law that has superseded national law. And so that concerns, obviously, all the law of obligations, contracts, torts, restitution, all that. But, of course, to succession, partnerships, matrimonial property, whatever you like. I mean, there's very little in private law, anyway, that's been left out. In addition, of course, to all the codified instruments, there's this enormous body of case law. handed down by the European Court of Justice, and it is absolutely impressive. And I challenge anybody, even Simeon, to know all the case law. I mean, it's quite extraordinary. So every single concept has given rise to a preliminary ruling, and there is more and more of it. It's very, very difficult to actually keep track of it. But luckily, there are the Germans who are doing restatement-like work by all these incredible commentaries that are coming out on the EU instruments. So we've got all of jurisdiction. We've got many of the instruments that have given rise to restatement-like commentaries. To what extent the comparison is really apt there, we could go into this. But anyway, there are efforts to kind of bring coherence to all these different fields, including the case law, the encyclopedias and commentaries. So this edifice does exist, and I would say that globally it works pretty well. I think it does work. Most of the complaints about the edifice have come from the English contingent here. And I would say that most of the European Court of Justice's misdemeanors, there are some notoriously bad cases, like a case called the Owuzu case, in which the court said that the scope of the Brussels ex-convention, now regulation, which is about jurisdiction, applies whenever the defendant has its domicile or seat within an EU state, whatever the links with a third country. Now, that was a direct response, actually, to an English idiosyncrasy. And so I think one could say much. I think we could take the cases one after the other and see that had there not been an English idiosyncrasy, probably the court wouldn't have ruled that way, and probably the remaining body of case law would have been quite coherent. So that's one claim. Anyway, on the choice of law front, there has been a very interesting move that Simeon has documented now for some time towards a kind of a middle ground, which is both maintains predictability, but nevertheless flexibility with all sorts of covert and other flexible mechanisms. There has obviously been an enormous influence of US scholarship and practice on the way in which EU private international law on the conflict of laws side, that means excluding jurisdiction, has evolved very, very definitely. I think probably the main influence came through the Hague Conventions. But I mean, when you know that the European Parliament consulted Simeon on how to draft Rome II, then maybe this influence is not that surprising either. But definitely this balance has come through an influence of the US tradition. And although it's definitely not perfect, and there again I refer back to Simeon's analysis, which is a standard European reference, Simeon's article called Rome II, A View from Across the Atlantic. We actually always use Simeon's analysis of Rome II, in which he points to exactly what he was talking about earlier. How can you have, for instance, Rome II is about tort, choice of law principles in tort. So it is designed to mix flexibility and predictability. It brings in, for the first time, an exception in favor of the law of the common domicile of the victim and the defendant. But it covers conduct regulation, as Simeon was saying, and perhaps that's not such a good idea. However, within the instrument, there are all sorts of other ways in which one could actually come back to something that's perhaps more focused. Whatever, those are details. Basically, it's a mix. Rome I is the twin instrument on choice of law in contract. It's already been reformed since its initial appearance. And curiously, in view of what Richard was saying earlier, it was actually the UK that made Rome I go back to more hard and fast presumptions, and not the reverse. So there's something we could talk about later. Anyway, the big novelty, I think, on the European scene is a move towards a differentiation between intra-member state conflicts and international conflicts. In other words, obviously, the tradition in Europe pre-EU was having exactly the same rules for everything, because nobody was in a federation or in a quasi-federation. Initially, the idea, I think, in the first private international initiatives within the EU was that a good rule ought to be able to be used within the EU and without, because European states thought of themselves as sovereigns, and therefore there was a sort of a look towards the rule. I think the movement is towards a differentiation for reasons, there again, that I'll go back to and that have already been mentioned. There are various specific things between member states that come up and weigh upon conflict of law solutions. And also another point which I think is important is that the differentiation took place for fairly obvious reasons via the jurisdictional instruments. And the key instrument in the whole European judicial space is not actually Rome II or Rome I on choice of law, it's the Brussels regulation, which regulates jurisdiction, and obviously it only regulates jurisdiction as between member states. And as there is more and more emphasis on actually jurisdiction or the authority competent to do something, that is true in all the new texts, and I'll go back to that in a minute, there is more and more differentiation between the two sets of problems because of the jurisdictional focus, I think. So what I'm going to do is talk very, very quickly, about interstate and then international conflicts, and see what the EU has done okay and what it hasn't done okay. So let me take interstate, intra-EU conflicts. The clear choice within the EU very early on was for the federalization of private international law, so the federalization of rules, for various reasons. Interestingly, subsidiarity has worked here, the principle of subsidiarity has worked here to reinforce uniform private international law and not the reverse. One of the reasons being that uniform private international within the EU has been perceived as one way of not unifying substantive law. Either because unification of substantive law was not perceived as desirable, or because it was perceived as too difficult, and that's what the court saw before anybody else, and started talking about mutual recognition. So that's a very, very important point. Private international law is a sort of a pièce maîtresse in the whole EU system, and carries with it a whole lot of objectives, which is why, there again, it's very significant that there's a significant differentiation between intra and external conflicts. On interstate conflicts, I'll go very, very quickly. Things that have been addressed recently in the EU are quite interesting. First of all, there has been a big debate about whether, I would say, federal constitutional considerations, the equivalent within the EU, have any impact on choice of law. So when I read these questions which come from the original, actually originated in Italy and then have been taken up very much by the Germans. They're called hidden conflict of law rules. But I very much remember an article by Douglas Laycock about territorial states and how that impacted or should have impacted on choice of law. And it's the same type of debate. Are there kind of implicit constitutional constraints on choice of law? The European Court of Justice has said yes, in certain circumstances, there's something called an exception of mutual recognition, which actually impacts on the way conflicts work between member states. The other very important thing is that human rights, or the European version of human rights, or the European fundamental rights, or whatever, actually do carry choice of law principles in the form of the idea of recognition of situations that are already constituted, and therefore that is a very, very important part of the European scene in choice of law, and it has recently given rise to enormous debate and enormous political conflict within each member state because of international cross-border surrogacy and its effects. And the idea of recognition has come up here in a big way. And the EU has been accused of many, many things that it's not really responsible for, but that doesn't matter. Never, even in the Brexit debate, it doesn't matter. But it's a very, very important part of the scene. In the international field, in international conflicts, as I was saying earlier, we have jurisdiction based on the defendant's domicile. So there are a lot of ATS type of situations which aren't necessarily problematic jurisdictionally in Europe. So people like Royal Dutch Shell and Trasfigura can be sued before a member state of the European Union. Our problem is when we get to choice of law in those cases, one reason being Rome II. I won't talk about that because I haven't got time, so I'll shut Ralph's alarm clock off. And the other reason is that human rights obligations do not have extraterritorial effect. In other words, there's an interference here of what we call horizontal effect and what you would call the state action requirement, which actually means that even if you can bring Royal Dutch Shell before a Dutch court, in terms of applicable law, you would probably apply, you use Rome II to get to Nigerian law, and then if you try and get rid of Nigerian law to bring in some kind of human rights obligations, you would come up, and using your public policy tools, you would come up against the non-extraterritorial effect of human rights. So that's not good. There's been a really bad example of this in the UK recently in terms of actions brought by Iraqi citizens for abuse in Iraq by British troops. And the Supreme Court has just handed down, or a few months ago, handed down a decision using a conflicts of law analysis and saying, so sorry, the action is subject to statute of limitations in Iraq, so we can't hear the case. So, there's no lesson to be given here, clearly. The one positive thing, I think, and I'll end on this, is that in Europe, we don't talk about extraterritoriality. In human rights language, there is this vocabulary, but in private international law, there is not. I think that's greatly liberating. We're not encumbered by the pair territorial, extraterritorial. From my perspective, the whole distinction does not make sense. I think that if you say territoriality, but you nevertheless take account of territorial effects, I don't really see what's territorial about it. I think it's a way of describing connections, and I think you can have territorial type of connections, but non-territorial scope. So I think that it's a help not having that vocabulary, and I think that's probably if there's one lesson or one positive thing to be said, it would probably be on the fact that we can talk about scope and whatever without using the vocabulary of territoriality and extraterritoriality, which I feel very confusing. Thank you.
Thanks, both. So you both think extraterritoriality is important to think about, except that Hannah thinks we should have more of it, and Horatia thinks we should have less of it.
In words.
No. I actually don't.
I want to try to formulate a question that actually asks that. So, Hannah, you do say we should think about scope. But of course, presumption against extraterritoriality is a very different way of thinking about scope from Curry's post-Curry interpretive mode, which is deliberately non-territorial, right? Which also looks at scope, but looks at it very differently. So thinking yours one step further, is the scope approach, should that be one of presumption against extraterritoriality, or should it be one that is interpretive as based on purposes, etc.? And the same question in the end also for Horatia, to the extent that we do think about scope in European private international law, which we do far less, I think. How do we actually do that when we don't do it through territoriality?
So, when I approached this question, I was thinking about it from the perspective of someone trying to restate the law of the United States, not on a blank slate. If I were writing on a blank slate, so I agree with Linda, I think governmental interest, or the label of governmental interest analysis, is not particularly helpful. And I agree entirely with Horatia that, I mean, we've talked for decades about objective territoriality and subjective territoriality, and how the whole concept of extraterritoriality makes no sense whatsoever. In the world of effects jurisdiction and so forth. I totally agree with that. So if I were queen of the world, I would get rid of a lot of these labels and all that. But I really was approaching this from the perspective of a restatement. And it seems clear to me, especially after recent Supreme Court jurisprudence, that we are totally stuck with the presumption against extraterritoriality at the federal level. I mean, that has been entrenched, actually, if anything, by recent decisions. And so the question to me is, what should this restatement provide courts who need to grapple with questions of legislative scope, also with respect to state law? And in some circumstances where the distinction between an international application and an interstate application may make a difference, in circumstances when the presence or absence of explicit geographical limitations may make a difference, et cetera. So, okay, so I suppose one way to deal with it would just be to ask, in the interstate context, right, where we have the constitutional structure in place, do we need a presumption at all? Or should we, in fact, be saying there is none? In other words, given the limitations of federalism and the limitations imposed by the Dormant Commerce Clause, we do not need a presumption against extraterritoriality of the kind we have at the federal level. I think that might actually be correct. We would still have to grapple with the application of state law in the international context, when maybe some sort of presumption would still be important. But so I'm I guess my argument is not. I mean, maybe at the time I work on the written version of this paper, I'll be more normative about it. But up till now, I mean, I'm thinking more. How do we need to think through for the draft dealing with these distinctions? Does that make sense? Yeah.
Okay, you want me to follow on?
If you want, you don't have to.
Yeah, so Europeans do much less scope analysis. Is that was your point? I don't know.
I thought that was your point in part.
But no, my point was about territory, using territory. No, scope analysis in itself, you're right that it's traditionally we're meant to have multilateral conflict of law rules. So the scope analysis always comes in as an exception. So it's the exception in favor of mandatory rules, for instance. But the territory language doesn't interfere, really, apart from the human rights question. But otherwise, nobody asks whether law is territorial or not. And I think, this is clearly well known for historical reasons. There was no Hobbes in continental Europe, and there was the Catholic Church, and extraterritorial personal status followed everybody around, and there isn't this historical luggage of territory that accompanied the Dutch school and the Anglo-American vested rights, etc. tradition. So we just don't use that vocabulary, but there again, things are very complicated, of course, because we probably do in public law. In other words, the presumption is that all this is about private law, which of course it isn't, but that sort of assumption, let's say, carries over, and so allows Europeans to think about all law in terms of scope and whether it's personal or not, even when in fact we're talking about very regulatory and very public law issues, but the label private allows us to do. Probably this is what Simeon was talking about when saying that Europeans do things covertly. This is probably exactly that there's a label which allows you to do a lot. But I think scope analysis is actually very, very present in European reasoning, particularly through mandatory rules and word police. You ask what the policy is, and then you ask whether it reaches these particular facts, and then hey presto.
Hey presto, everyone.
Horatia gives a nice juxtaposition of the European and the American system. I think you underemphasized, or maybe completely omitted, that the fundamental tendency is completely opposite in the European Union. We have centralized conflict of laws. In the United States, we have decentralized it.
Yes, that's why I was talking about subsidiarity.
We have in the European Union, we have centralized conflict of laws. Federalized, right? Because the Europeans are very uncomfortable with anything that's not centralized and uniform. And on the American side, the inclination is exactly the opposite, is not to centralize it. Congress could make a choice of law statute, but we would never dream of that. It would be politically impossible and probably not prudent. And that gives the whole thing a totally different turn, right? Because when you do anything legislative in the European Union, you sort of do a one-size-fits-all thing for all the EU members with lots of spillover effects into the non-EU members. And so you got to be careful that that uniform rule really fits everybody. And then the British example, which you mentioned, is sort of the test case, right? Does it even fit Britain when it does form non-convenience with foreign countries? And the answer may very well be no, but it's roped in. This is a almost no holds barred, no mercy, no outs centralization project. And in the United States, we're doing exactly the opposite. Right? We leave it to the states, and we're extremely reluctant. The Supreme Court, at least, is extremely reluctant, and Congress is extremely reluctant to interfere. It's just let the thousand flowers bloom and see how this all works out in a chaotic state. What I find interesting is the restaters find themselves sort of in the middle, because they're supposed to write something that is uniform in a sense, right, to some extent. And in Europe, that would be a piece of cake, because you would be completely in sync with the political trends. Here, it's sort of out of sync with the political trends, because you got to consider that every state can do whatever they want, and yet you kind of try to maneuver them towards sort of, like a very benevolent German shepherd, not a mean German shepherd keeping the flock together, sort of a benevolent German shepherd, trying to rally them around some common ground. And so that's why it also makes me very skeptical when you look from an American restatement point of view to Europe. So on the one hand, that's not what you should do. Right? On the other hand, that is sort of what you want to do. because to some extent you're in line with them, and to some extent you have the opposite inclination. That's another reason why we should be very careful, very cautious before we extrapolate from one system to the other, beyond the jurisdictional grounds and all that.
I was reluctant to speak, but I've been given a sort of a green light now. I can follow on legitimately. I should say, for those of you who are not familiar with European conflict of laws, it was a very dangerous thing for Horatia to mention the decision of the Court of Justice. Because if you say that in the presence of an English lawyer, it is going to lead to a reaction. I hereby react, but it's entitled to do so. I mean, yes, I think there is a general lesson here. In a supranational system, I'm not qualified to say anything about the operation of a federal system, but in a supranational system, first of all, you have to decide whether you are going to have absolute uniformity or whether you are going to allow subsidiarity. And for all kinds of reasons, which are partly political, of course, in the EU, it's always been assumed that generally, not actually in relation to choice of law, but generally, there is a space for national law. Now, of course, the difficulty with that is the moment you do that, you have boundary disputes. Now, let me say immediately that although I have many reasons for not saying this, I will be the first to admit that in terms of rationality, there is something to be said for the proposal, which died eventually when the Brussels regulation is being redrawn. There's something to be said for the proposal for having absolutely uniform jurisdictional rules and not distinguishing between defendants domiciled in member states and not domiciled in member states. Of course, the UK argued strongly that they wanted to retain the space for national law in cases where the defendant was outside the EU, but that didn't happen. Interestingly, actually, because the Germans didn't want it to happen, so we sort of got off free there. We weren't guilty of stopping the harmonisation. But anyway, the point is, once you have the boundary dispute, then you have to decide how the boundary is policed. And I have to say that is something, at least in the private international law area, where the EU has signally failed. It has simply failed to grasp the nettle. Which brings me to Roosevelt and Jackson. Now, the issue of Roosevelt and Jackson, I should say for those who don't know, is actually very simple. This was a situation where the defendant was domiciled in England and therefore subject to the EU jurisdiction rules. Therefore, the English court had jurisdiction over the defendant. But the subject matter of the dispute related to an alleged tort in Jamaica. Well, as the Court of Justice quite correctly said, the fact that the subject matter of the dispute related to Jamaica was neither here nor there, and I think that is true. But the difficulty is this: the defendant sought a stay of the proceedings using the English national rules concerning fraud and convenience, on the basis that the EU regulation governed the grounds of jurisdiction in this case, but had nothing to say about the circumstances in which jurisdiction might be declined. Highly controversial issue. When this went to the Court of Justice, they struggled, I think, to find a way of stopping the doctrine of fraud and non-convenience from continuing. The argument that was put, and you'll see where I'm going with this, was that since the underlying purpose of the EU conflicts regime is to ensure the mutual enforcement of judgments between member states, it made perfect sense, therefore, that we should have uniform rules for the staying of actions as between member states, but it made no sense to say that national rules should be ignored in cases involving non-member states. Anyway, the point about that argument was that it was a coherent argument which related to the objectives of the relevant instrument, Brussels I regulation. What is very striking, and where I pick up on your point, is that, of course, the Court of Justice bypassed this, I have to say rather cleverly, because they said there is a higher objective. This is an EU instrument, therefore it has to serve a higher objective, an objective over and above the objective in the instrument itself, which is to ensure the workings of the internal market. How do you ensure the workings of the internal market? You do it by achieving uniformity in the rules of private international law. So uniformity becomes an end in itself. But the moment you say uniformity is the end in itself, what does it mean? It means that rules of national law simply can't survive. So you're policing the boundary dispute, as it were, without any relevance to the specific objectives of the regime. You're just saying uniformity is an end in itself. But that's far too simple an answer. I have to say, just as a footnote, I don't think this is entirely an English difficulty. I know that the case arose because of our distinctive doctrine of fraud and non-convenience, but the question was not, is fraud and non-convenience compatible with the EU regime or not? The question is, are national rules for declining jurisdiction compatible with the EU regime?
Well, I'm actually going to try to pose a question, and it's to Hannah. and it is, can you talk me off the figurative ledge? Because if I look back at the last 4 Supreme Court cases on extraterritoriality, so we got RJR, Kiobel, Morrison, and Hartford Fire, right? I think
Or Empegran?
yeah,
Up on the road, yeah.
skip that one. Let's go to Hartford Fire. I like that better. All right. If I were trying to restate them, I guess my restatement would go as follows. If the Supreme Court doesn't want federal law to apply, it finds something that didn't happen within the United States, although the thing doesn't have to be the same thing. In Kiobel, it was the conduct. In RJR, it was the damages, and in Morrison, it was
The transaction.
the price of the trade. And if it does want federal law to apply, then it finds something, not necessarily the same thing, that happened in the United States, which was the effects. So that would be my restatement. Tell me where I'm wrong.
Well, okay, so first of all, a restatement of the federal presumption itself belongs more logically in where it is, in the draft foreign relations restatement, right? And, what the draft foreign relations restatement just says in summarizing the presumption against extraterritoriality is that, the courts interpret to apply only within the territorial jurisdiction of the U.S. unless there's a clear indication of intent to the contrary. And the innovative step in Morrison was this whole second layer focus analysis, right? So first we ask whether there is clear congressional intent that the statute apply beyond the borders of the United States, and if there is not, I know. Well, but I think this is underscoring Horatia's point, right? Which is that using the label territorial and extraterritorial is not very sensible. Which I agree with. I mean, of course, there's some coherence to all of those decisions in that it is pulling back tremendously the application of American federal law in the international context. There's also logic if you want to connect it to the evisceration of the private right of action under securities law, under RICO, there are lots of ways to provide coherence to this line of cases. But if you're looking for coherence in the label of territorial versus extraterritorial, no. But again, we've always known this. As soon as we start talking about the distinction between objective and subjective territoriality, what we are saying is those categories have little conceptual value.
The course of this is what exactly the Supreme Court was talking about in the Hyatt versus Franchise Tax Board case with regard to full faith and credit and its effect on territoriality. I'm not going to ask you to do that. I just would like some help because I have to teach that class. I have to teach that case to my students, and I would love to be able to explain what I find to be inexplicable. But
Before we help you teach your class, let's get Simeon and Linda.
A couple of things. The Europeans are moving too fast in centralizing private international law, and they are making mistakes, some of which are really avoidable. And it's sometimes because of the political tension, sometimes not. And there are politics, not just the national politics, but the commission politics. They want to show something, and every country that has a presidency has to show something during its 6 months and all of that. So, on the other hand, we are at the other extreme. 200 plus years, we didn't centralize anything, for better or worse, in any event. And the other thing, the Europeans don't mind discriminating against foreign defendants, and Brussels I is a good example. Where defendants domiciled outside the EU get the worst of both worlds. They are subject to exorbitant basis of jurisdiction allowed under national laws, and then the judgment that one can get in one European country circulates throughout the EU. So it is really a very bad regime. It was my bad luck. I was chairing the working group during the last 6 months of the Brussels I recast, and I proposed what I thought was a fair compromise, that you can keep your national exorbitant jurisdictional rules, but at least don't allow the judgment to circulate throughout the EU. And you know what the response was? Well, we want some leverage against the Americans at The Hague. If we give them this now, what are we going to get at The Hague? Back to the presumption against extraterritoriality, I don't think that this will have to last forever. It's a relatively recent phenomenon. Maybe a different court will begin eroding that presumption. And even now, it doesn't apply to all cases involved in federal statutes, and certainly federal common law. For example, if you all remember, Lauritsen versus Larsen and Rhoditis, all the maritime law cases, they involve the Jones Act, which is a federal statute. The court resolved the conflicts in that area of the law through a multilateral approach without any presumption against extraterritoriality. So when you have, and to this day, when you have maritime personal injury and other maritime conflicts, even maritime contract conflicts, nobody's talking about the presumption against extraterritoriality. So, as bad as it is, it doesn't cover everything. And it would be, I think, a very unfortunate development if we were to enforce that kind of presumption in conflicts before state courts, whether of the interstate nature or the international category. And I don't think you are suggesting that, Hannah. I am concerned about the cases you mentioned recently, but the better cases really do not follow any such presumption. For example, the California Supreme Court, in all of its cases, has not abided by any such presumption. If anything, it goes the other way. And the New York Court of Appeals the same way. And in that context, I would defend the two-step analysis that the reporters are proposing as in their draft. I think what they are doing is what Judge Traynor told us we should do. You first ascertain the intended reach of the rules of the two states, whether they are statutory or even common law rules, and then the three possibilities are there. The rules overlap, that's the true conflict, or only one of them reaches the case, that's the false conflict, or neither of the two rules reaches the case, it's the unprovided for case. But this is the preliminary step of any choice of law analysis. Where the restatement comes in is to say, okay, if you have a conflict, as they are telling us in 502, then the priority rules we give you should be followed. But I think as a way to describe the choice of law analysis, I think that is as good as I have seen. And I hope we do not abandon it. And if anything, maybe we can fill in some of the blanks. But I think it's a good way of describing what happens when a court gets a multi-state case. This is the first step of the process, I think. So I will applaud the reporters for having it in there, and I hope we manage to keep it.
Although, can I just, so let me respond first on the extraterritoriality point by saying, so there are some cases that say explicitly that there is no presumption against extraterritoriality for state statutes, right? I just think, given the amount of cases that do talk about a presumption, it needs to be clarified so that courts know what they're doing. On your second point, and I would love if Kim wants to talk about this. So my read of the draft is not that courts do this. My read of the draft is that the two-step analysis is, as I said, a kind of philosophy of conflicts thinking that undergirds the specific rules that have been set forth, like in the tort section, and that will be set in the property section, that will be set forth in other sections, but that in the event of a multi-state case, the court does not begin with an analysis of legislative scope. The court goes to the rule. At least that was my read from what you said at the last meeting. So maybe you can talk about that.
The two-step model, it's supposed to be descriptive because we do think that most modern approaches can be described from this perspective. I think analytically, if you think about it, that's basically what modern approaches do. It's supposed to facilitate clear discussion. So I think it allows us to draw some distinctions that are useful to draw. But there's no, well, Simeon actually made a very good point about this at the advisory meeting. There's no stage at which we tell courts this is how you start. So what we say is, this is how we think the choice of law process works. This is how we've derived these rules. So for the torts section, in particular, we say we divide laws into conduct regulating and loss allocating laws. We make assumptions about the likely scope of a conduct regulating rule and assumptions about the likely scope of a loss allocating rule. Then we look at different factors and we say what the factors are. It's basically the domicile of the parties, location of conduct, location of injury. With a particular kind of rule and a particular arrangement of factors, you get a false conflict or a true conflict or possibly an unprovided for case, although I don't think we really have any unprovided for cases. And here's how we've resolved it, right? So loss allocating rule, common domicile, injury in some other state, apply the law of the shared domicile. And courts are supposed to go to those rules, right? That's what they do. Now, Simeon pointed out, well, you've got a residual rule. And in that case, if we've got a tort or a constellation of factors that we don't address in the specific rules, then, yeah, I mean, I think a court should go on and do something sort of like that, and we should probably try to spell that out in more detail exactly what we want them to do. But the main significance of the model is supposed to be, here's how we got the rules. And the main value there is in part because, I do think this is a useful way to think about it, but also because it can let you see when our rules are going wrong. So, for instance, we make assumptions about the likely scope of a state law. A state could say something different. A state could say in its statute, this law is territorially limited, even though you might think of it as loss allocating. And in that case, and this is the practice of courts, we don't think it's okay for some other court to apply that law to an injury that occurs outside the state, even if it does have two of the state's domiciliaries, because the state has limited the scope of its law. We think that's within the power of the state. So that's when the manifest and more appropriate exception would come in. And it sort of works like that. But you're not suggesting that we should get rid of this distinction between scope and priority, are you?
No.
No. Okay.
I just think, I mean, to me, in a sense, if you commit to that method, you could sharpen it, right? In other words, you could do more like what Simeon is saying, which is that could be actually what we expect courts to do. We expect them to start, which feels very interest analysis like, of course, although it doesn't have to get to the same end as interest analysis because it doesn't necessarily have to default to application of foreign law.
Oh yeah, we're not doing that.
No, I know. And you could also say that we expect courts to follow not just explicit statutory limitations on scope, but also other limitations on scope, right?
Which is
in
a
other
very
words,
interesting
you
question.
could
I
take
think
that
there's
method and
theoretical
make it sharper.
Case to be made for that. You're the only person who has suggested that, I think. I mean, generally speaking, we get a more negative attitude to that, but I would love to see what the cases are. So generally speaking, we're trying to go with the cases.
Yeah, and I think some of the cases are actually the cases that talk about the presumption against extraterritoriality as an implicit limit. So I actually think that's where some of these decisions.
Right. Now, I would like to talk to you about this more. I hope that you are writing out the paper, but I'd like to.
Yeah. And again, I'm not
cases
pushing this myself. I'm just saying, I think the draft it could be clearer how committed. Yeah, the new restatement is to this process. I'm not saying it should be.
Well, I mean, I like to be true to the theory. The problem is that the cases aren't necessarily, so the cases are not necessarily coherent. And, with the restatement, we try to have a theory that explains what they're doing and looks rational and coherent and tells courts what to do. in future cases, it's not always the case that there is such a theory. So we can't necessarily have the perfect, full, pure exposition.
Okay, Chris first, because it's right on this. Yours is something other, right?
So I'm happy.
Okay, so you'll have to do that after that.
Yeah.
Sorry.
I was just gonna say, one of the attractions, I think, of having the two-step method inform the rules is simplicity for judges. And maybe an intermediate position would be in the residual clause to provide more explicit guidance when a judge has to make the decision other than through the application of one of the black letter rules, but keep the black letter rules, maintain those black letter rules as if they already incorporated the consideration of the two steps. Yeah, because I think that's one of the attractions of having just apply the rule.
I would think it's one thing that several advisors were unclear about, right? Mm-hmm. And including the question whether you translate scope assumptions into priority rules. So if you can clarify that, I'm sure it would be very helpful. If I don't understand something, I trust it's my fault. If Lee Brillmeyer also doesn't understand it, I trust maybe you want to explain it again. Linda.
Wants to continue that. Is yours responsive? So
in a way, I was going to go back to the extraterritoriality point because I do.
Then I got Linda first.
Okay, I was going to go to the extraterritoriality point as well. I may be one of the few people in the room who actually thinks the presumption has a great deal of force in the foreign cases, and I think it's right. And Hannah emphasized this as she drew her distinctions, because one of the things you had on your little chart was separation of powers, and I think that's motivating this. I know Andy Lowenfeld would be very unhappy to hear me say this, and I'm really sorry, Andy, with all of his criteria in 403. But, again, there were no rules. I mean, it was really sort of impossible. And as difficult as some of these issues are, all of the cases have sort of invoked the presumption from Ramco on. The exception are sort of extraterritoriality. And the reason is when Congress comes back in, they can do it better than the courts and try to deal with some of the comity issues that are involved. So in Aramco, they revise the statute, make it apply, but try to deal with the potential tensions in the workplace. They do it again in Morrison with Dodd-Frank, and they draw a distinction between the Commission and the DOJ and private rights of action, which they think may be interfering in a variety of ways. And similarly, the Supreme Court, even in RJR, where they could have analogized to antitrust, use their own analysis on the predicate act point, and then draw a distinction again between when the government acts and there's an express provision for a private right of action. So I think there are problems with the sort of what the focus particularly is, but I think the movement toward rules and away from the sort of amorphous sort of this factor, that factor is really a positive development. And I think, analogizing to what one is trying to do in the restatement, trying to move to rules is a better approach. I just had one other sort of question, I guess, to Horatia. It picks up on Matthias's point. What was always very interesting to me were the Rome 1 and Rome 2 and the European regulations, which apply to everyone. And of course, there was the divide on jurisdiction, except that the movement seems to be in the universal direction as well. I know the attempt to have rules for the same jurisdictional rules for third states failed, but that was largely sort of political, wasn't it? I mean, to say, what are we getting for this when we are eliminating the exorbitant rules? And also in the jurisdictional statement, in the recast, you've added in some situations rules that reach third states in the consumer area, and maybe more surprisingly, to me at least, the lease pendens rules when you don't deal with judgments and then have now a lease pendens rule that applies to third states. So, if anything, the Europeans are moving in a direction not to distinguish between the European case and the third state. And at least in choice of law rules, maybe we'll talk about this more, but on the pure choice of law rules, I'm not sure that we really ought to be distinguishing, but I'll say more about that tomorrow.
Okay, can I just make a footnote? To those who are not completely familiar with the European system, there is pretty big room for defection. Right? It's not a complete system, meant to be a complete system, but not all member states are by any means agreeing to all regulations and all rules. And in the Brussels regulation, it's built in.
UK and Denmark.
Yeah, the UK and Denmark.
And Ireland.
Yeah. Well, with the coming regulations in the family law area, there are more, right? So it's not a watertight system. There's political defection.
But tort and contract. I mean, let's just stick to tort and contract for them.
Trey and then Paul.
Yeah. So I wanted to second Hannah's call for the restaters, advisors, everyone to take a sort of a deeper look at the state extraterritoriality cases, because whether or not it's a one-off, whether or not the court's changed, it's had a domino or ripple effect in the lower courts. And so you see a couple of things. One is, putting outside the federal context, you see when it comes to the application, extraterritorial application of state law, sometimes that's resolved through forum non-conveniens, means they just never get to it. Sometimes it's resolved through choice of law, which means they just apply forum law because there's enough of an effect. And why is there enough of an effect? Because we have jurisdiction, so there's enough of an effect for purposes of personal jurisdiction. There's necessarily enough of an effect for purposes of choice of law. Sometimes, and mostly you see this in federal courts, they say, well, the presumption also applies for U.S. state law, especially U.S. state statutory law. And sometimes that conflicts with what state courts do. There are some state courts who do say there is a presumption against extraterritoriality, at least for some statutes. But in other contexts, they say there is not. And then I think the big issue is common law. And there was a recent case, this is from the 11th Circuit, it was the district court opinion in the Intra Chiquita alien tort statute litigation, where the district court refused to apply state law because he said application of state law would violate international law. And it's one of the few cases where I've actually seen that sort of stated explicitly. And so what he ended up doing is applied lex loci delecti, the law in place was, what was the law in place in Peru? I guess it was Nicaragua. And so that was the law that was to be applied. But it's one of those few cases. There again, he had arguments for extraterritoriality. He had arguments for forum non. I think originally he did try to get rid of it under those grounds, and then came back to it because he realized he had standalone diversity jurisdiction and he needed to sort of make a different decision. But it would be it's something I think that should be looked at. Both as a problem is I don't think there's a clear rule necessarily that you can restate at this point. But what you can potentially do is give the court standards of analysis, or even take a deeper dive into what the 50 states are doing when it comes to extraterritoriality of state law, not as the federal law, but extraterritoriality of state, and differentiate between state statutory law and state common law.
I wanted to echo Trey's point about looking very carefully at extraterritoriality impact or scope of state law, but for kind of different reasons. So I think the most interesting question after Morrison is, will states fill the regulatory void? And should the restatement say anything to them about that and gap? And the problem with most of the state's case law that you're going to find is it's pre-Morrison. And it's suspect for that reason because the states that were acting on that always had the federal government to rely on to act regulatorily. Why would they want to use their own resources to do so? So to the extent to which that's representative of what they do going forward, I have some doubts. I think an approach you might like, particularly descriptively, is create a lot of room within the restatement for states to make some choices. And you can look at that data further in the future. I would expect it would shake out, in addition to what other people have said here, I would expect it would shake out the following way. Which is the state we're talking about? So some states are jurisdictionally and choice of law aggressive and can do so. Some states are quite conservative because they don't want to scare away foreign investment. And so what you would expect something in the choice of law or scope analysis that matches somewhat what you see in the long-arm statute analysis. So they vary. California goes up to the limits of the due process clause. Other states pull back much further. And so I just think the overriding more important thing is not to be so tied to that state decisional data as not to recognize that there was a change in the federal presumption taking place. And what's going to be on the other side, I would like at least leave the room that states may fill the regulatory void, they might even fill the human rights void, because I don't think Garamendi or the Burma law forecloses that. Those are very fact-specific cases.
And just to operationalize this within the current structure of the restatement, there's at least in the version from the last advisors meeting, in the comment, I think there's a reference to various sources that you can use to try to determine the scope, the statute itself, common law, the Constitution, and that allows the judge who has to, in a residual situation, to make that determination to make an open inquiry to what those limitations are in a given state. But we could add to that perhaps some guidance that would suggest the importance of the distinction between the purely domestic situation where there's the constitutional context and the state law, foreign country law dimension, which may implicate other situations, and perhaps even add a reminder to judges faced with these problems that they're not bound to follow the logic of Morrison. So there could be a compromise between trying to restate with very scant case law and leaving it completely open-ended, perhaps.
And I think it's just important to point out the difference the way federal courts and state courts are treating this. Because I mean, it wasn't surprising when I started to look at it. I mean, even in the Foreign Trade Antitrust Improvement Act stuff, the federal courts are saying, no, we should interpret it as coterminous, as you said earlier. And we shouldn't let state laws go broader than the federal antitrust laws. But I don't know if state court judges would necessarily do that. And I think you see this in the extraterritoriality where you don't necessarily see a lot of state courts necessarily using that language unless there's a prior direction from the state Supreme Court to do so. They're dealing with it using other methodologies, sometimes reaching the same result, but not doing it through the same language that the federal courts are doing it. And then I think we are in this phase where, I mean, how far will the dominoes sort of continue to fall, and will the extraterritoriality analysis continue down to state courts, or will they be resolving it under different principles?
I have a, yeah, you can, of course.
Can I respond to Richard, Matthias, and Linda?
Absolutely.
Yeah, about the centralization point. That's exactly the point I was making. That the Europeans have interpreted subsidiarity in a way to give more force to private international law to avoid substantive unification. But of course, it's going much too quickly. And I said it sort of worked more or less. I'm not here to defend the EU model. It's going much too fast. There've been a hell of a lot of mistakes and everything. But that's its point. That's what it's trying to do, right? It's trying to build private international law into as a very, very important tool in a quasi-federal structure. But of course, I think that there have been mistakes. The Owusu is a terrible. I've said it myself. Owusu is a terrible decision. But I think it. So this is the same thing about the scope of Brussels I. But it's only there because of forum non-convenience. In other words, had there not been that English idiosyncrasy, they would never even have thought about the scope of Brussels I, I think. So that's the point I was making, but I'm not defending Owusu absolutely at all. And as for universalization, yeah, sure, in Brussels recast, there are some attempts which are the sort of vestige of the idea of opening it to make universal jurisdictional rules over defendants from third parties. But the trend that I'm looking at in many of the special instruments, for instance, succession, is that there's a synchronization of jurisdiction and choice of law. In other words, once you know that the jurisdiction or the authority is competent, then that authority will just apply their own law. And that's very, very specific. And I think it's sort of localizing I think it's a trend. Yeah, I think it's a methodological change, and I think it's more and more frequent in these special instruments, yeah.
So I think there would be lots more questions, but I think the void that Paul mentioned as a regulatory and human rights void might also happen in our brains, in mine certainly. So I think we'll keep the questions for tomorrow, and we'll close for today, and I think reconvene at 8 for breakfast or at 8:30 for the conference tomorrow, right? And except for speakers who have dinner and can talk about whatever they want. Thanks, everyone. See you either later today or tomorrow.